clerk to Judge Anita Harold Ashley. And I also want to thank Judge Ashley and her staff because they have welcomed Ryan into their court family, and I appreciate that so much. Ryan, I believe your brother Jason is watching from his home in Greenville, South Carolina.
Hi, Jason.
And I know that your dad is looking down from above so proudly. We are all so proud of you. And so I would ask this court to please seal our pride and grant this request that Ryan be granted the privilege to practice law here in the state of West Virginia.
Well, we certainly are honored to grant your motion.
Thank you.
And Ryan, we appreciate that you are continuing a proud tradition of honorable service to the court system that your mother has certainly shown as well, and you've already shown with your service with Judge Ashley. So we're very pleased to have you join the bar, and thank you for your work already as an attorney that you're doing. So
Thank you.
Please grant your motion.
Next, we have Carol P. Smith, West Virginia Bar Admissions Administrator, presenting the remaining 11 applicants.
May it please the court, Carol Smith, West Virginia Bar Admissions Administrator. I'm here before the court this morning to move the admission of 11 applicants to practice law in the state of West Virginia. The following applicants successfully passed the West Virginia Bar exam and seek admission to practice pursuant to Rule 3.1. Cayman Marcel Jarrow and Vincent Michael Ladon. The following applicants seek admission to practice law in the state of West Virginia by transferring their UBE score pursuant to Rule 3.5. Lindsay Germaine Carter and Arison John Gennaro Iliano. The following applicants seek admission to practice law in West Virginia by reciprocity pursuant to Rule 4.0. Patrick McDonald Delaney, having been admitted in Florida, Texas, and Virginia. Stephen Keith Eisenberg, having been admitted in the District of Columbia, New Jersey, and Pennsylvania. Abigail Marie Green, having been admitted in Illinois, New Jersey, and Pennsylvania. Ryan Arthur Keefe, having been admitted in the District of Columbia, Massachusetts, and North Dakota. Sarah Catherine McGuire, having been admitted in Kentucky and Virginia. Brant Tyson Miller, having been admitted in Ohio and Pennsylvania. And Thomas Alex Panaghetti, having been admitted in Pennsylvania. I represent to the court that each of these individuals has satisfied the requirements necessary to practice law in West Virginia and present the character and fitness to practice law in the state of West Virginia. So at this time, I move their motion to be admitted.
All right, thank you. Your motion will be granted, and we certainly are pleased to have each of you join the West Virginia Bar and wish you the best as you begin your legal career or continue your career here in West Virginia. We're very pleased to have you, those of you who are practicing in other states, to have you join the practice in West Virginia as well. So,
if there's anybody back there who wants to take pictures of this process, come up here.
yes.
So at this time, I'm going to be administering the oath. And so like I told you, family and friends, please take this time right now if you have your phone or another camera, if anyone still has those. Come up here on this side of the table so that you can face the applicants, and I would ask that all applicants stand at this time. Anyone who knows me knows that I want to be the one administering the oath to my son, and I'm going to hold him to it. So I am going to step back in my role here as clerk at this point. And of course he's shaking his head because he knows that what I'm saying is true. All right, applicants, please raise your right hand. I do solemnly swear or affirm that I will support the Constitution of the United States and the Constitution of the State of West Virginia, that I will honestly demean myself in the practice of law and to the best of my ability execute my office of attorney at law, so help me God. You may say I do. Congratulations to all of you.
Well, we'd like to invite my colleagues on the court to express their congratulations to you as well. So with that, Justice Walker.
Well, welcome to our beautiful courtroom. For those of you who haven't been here before, he'll probably tell you this, but just in case he doesn't, if you are interested in this courtroom, how it's designed, what we do in this courtroom, we have a really cool set of videos on our YouTube site called And Justice for All, featuring Justice Jenkins, talking a little bit. So we won't talk about the history today, but there's a lot of very cool history, including the two quotes, the Jefferson quote that you all can see, but when you leave, be sure to turn around and check out the Lincoln quote that we look at every day as we're in the courtroom. As those of you know, have probably noticed who have been admitted in other states, we love admitting new lawyers to the bar, and we do it in person whenever we can. We had a bit of a remote situation in the spring, but we're just thrilled that we are able to bring you into our beautiful courtroom and welcome you in person. We would normally come down from the bench and shake your hand and pose for photos. We're not quite to the point of doing that. We still have our plexiglass protecting us. Makes it look like the Kentucky Derby up here. But we would nonetheless very sincerely welcome you to the West Virginia Bar. Those of you who will be practicing here, we look forward to seeing you back in this courtroom soon.
Well, good morning. My name is Evan Jenkins, and it is truly an honor to have you here with us. Looking at some of the other states that several of you have been admitted to, I'm wondering, where did you get lost to find West Virginia? But we are sure glad you are here. We are proud that you have chosen to seek admission to the bar here in West Virginia, and we are honored to grant that important motion. As our clerk referenced, another one of our justices is appropriately social distancing, Justice Margaret Workman, and she has participated in many of these in her long service on this court, and I know how special these days are to her. And so I know she, like many of your family, are at home rooting you on. So welcome to West Virginia. Congratulations for the new admittees that are just starting their career. What an exciting future you have. We hope that you consider West Virginia home, and certainly the court as a place that you're comfortable in pursuing your profession. For those out-of-staters, we hope you come back often. That's the one thing you will always recognize about West Virginia is our West Virginia hospitality. And whether you're in a courtroom or at a bakery, we always appreciate one another, and we hope you feel at home here. So please come back often. It's a big day today. Congratulations.
Welcome. Thank you very much. I'm John Hutchison. I am the newest member of the court. Although there's a bunch of new members up here, it's just a matter of how long. But I'm the newest. And I am...
But not the youngest.
Yes, there you go.
Sorry.
I am...
Who is the youngest here?
I don't know. Who's the youngest
I think
here?
it's you.
Well, I know I'm the second oldest in terms of age to be sitting on the court, but I'm the newest member of the court. And I will tell you, 40 years ago when I stood where you all are, this courtroom has not changed that much. It may have been polished up a little bit, but I remember well being in your position and swearing an oath to the Constitution of the state of West Virginia and the Constitution of the United States. I have enjoyed my career, and I hope that you all enjoy your career in the state of West Virginia. And I hope that each of you at some point in time has the privilege, and it is a privilege, I believe, to appear in this courtroom and argue a case on behalf of your client. It's a big deal. and I hope that you have the chance to be part of it. But welcome. Thank you very much for coming, and thank you for coming and agreeing to dedicate yourself to the practice of law in the state of West Virginia. Thank you.
And I would just, we talked a little bit about the history of the room, and we won't go into it. As Justice Walker said, you can certainly watch the videos, but if you probably will be seeing over the next few weeks, I'm sure, a lot of coverage of the U.S. Supreme Court. And if you take a look at this room, this, as some of you may already know, Cass Gilbert, who designed our Capitol, was in the middle of, had already designed this room and this Capitol, and was chosen to design the United States Supreme Court chamber in Washington, D.C. And so if you look at this room and you look at the National Supreme Court chamber, you'll see a lot of similarities, because this was sort of the prototype, the practice run, so to speak, for the United States Supreme Court. It looks a great deal like the U.S. Supreme Court chamber. So it's an honor to have you with us today. We're very glad we're able to do this in person, and we wish you the best in your practice of law in West Virginia. All right. That's it.
petitioners in this case. We are here today on what I consider to be a fairly narrow choice of law issue with respect to a ruling from the lower court, Judge Hummel, that applied West Virginia law to some bad faith claims. So that kind of sets the stage for what we're going to be talking about, and then I will back up and give you some context. This suit, in simple terms, is a coverage dispute arising out of a loss that occurred in Marshall County on August the 27th of 2016. There was a coverage denial, subsequent litigation ensued, and those issues are at stake before the Circuit Court of Marshall County. At this point, the case has been reassigned to Judge Christopher Wilkes with the Business Court Division, so he is currently the presiding judge by order of this court. So, to start off, the policies of insurance that we're dealing with here, we have 13 policies of insurance that were issued by 12 different insurers, some located here in the U.S. and others located abroad. And for the benefit of the court, us in this business often refer to these types of policies as quota share policies or subscription policies. And you see that in matters like this, where these various insurers will insure a percentage of the risk. So it is it's a sophisticated insurance program. It's not like your garden variety policy that I might buy as a consumer. And in the placement of these types of policies, you have sophisticated parties like Axial Corporation and their broker, Willis of New York, Inc., who dealt with the placement of these policies. The particular policy in question was for the November 2015 to November 2016 policy year. And as I noted earlier, during that year, in late August, a loss occurred at the Axial facility. Now, subsequent to that loss, Axial Corporation was acquired by Westlake Corporation, and Westlake is a plaintiff in this as well. A couple of other facts that I think the court should be aware is that when the policy was issued to Axial Corporation in November of 2015, they were headquartered in Atlanta, Georgia. And so they were running their operations out of Atlanta, Georgia. But they had multiple properties insured across multiple states and multiple jurisdictions, and including the property located in Marshall County. So the policy, when issued and agreed by the parties, contained a broad choice of law provision. And it is the application of that broad choice of law provision that we are dealing with here today. As we put in our papers, Judge Hummel had a hearing on September the 5th of 2019 about some jurisdictional issues, and sua sponte, he made several rulings. And as we put in our papers, he made these rulings without briefing or argument. And in doing so, particularly on the choice of law issue, he stated that the choice of law decision was going to be made by someone. Perhaps it was better to be made by 5 justices than by him. And so he made it, and then he gave the parties a period of time to move for a writ of prohibition, and the insurers did. And so if you look at the order that is the subject of the writ, it's at 1646 in the record. The third paragraph of the order is really the one that is in contention here. And it states that Axial's bad faith claims under Georgia law are dismissed. The court finds that Georgia law governs the coverage issues pled in count 2, that's a breach of contract claim, and that the bad faith claims are governed by West Virginia law. And he determined that since he reached that determination that the Georgia bad faith claims need to be dismissed. In the petition, we asserted that this was particularly the ruling, specifically the ruling applying West Virginia bad faith law to this particular action was clear error of law. And we have disagreed with the other party about much in this case because the litigation is ongoing and discovery is ongoing on their declaratory judgment and breach of contract claim. But I think we do agree that Judge Hummel's ruling here was a clear error of law. Where we part company is in what we are asking this court to do. And I think that the other side would just like to see the court vacate the order entered by Judge Hummel dealing with the bad faith issues and send it back to the trial court. But we have not asked for that in our writ. First of all, I think the parties are in agreement that the Georgia choice of law provision clearly applies to the breach of contract claims. We have not challenged that ruling in our writ. We think it's right, nor has the opposing party challenged it. So we think Judge Hummel got that right. But as I stated earlier, what we think he got wrong is determining that West Virginia bad faith law applies to their common law bad faith claims and their Unfair Trade Practices Act claims.
How does this case meet the requirement of writ of prohibition? I mean, this case has now been transferred to the business court division. There would be nothing stopping the business court division from relooking at this issue and disagreeing with Judge Hummel and fixing it itself. So why in the world do we need to be dealing with an extraordinary writ on a very narrow question that could be corrected by the trial court to which it's been transferred?
Thank you, Judge Hutchison. Let me address that question. Whenever we filed the writ, we looked at the 5 factors that this court looks at as set forth in Hoover versus Berger. And the 3rd factor is whether the order is clearly erroneous as a matter of law. And I think it is, and I think the other side agrees that it is. And the 5th factor that we looked at was whether the order raises a new and important issue of law of first impression. And as we reviewed the case law, it does. And that is how this court is going to view the application of a broad choice of law provision with respect to breach of contract claims and common law bad faith claims and Unfair Trade Practices Act claims. So we think that the writ meets the factors set forth by this court, Judge.
Counsel, let me ask you, when you went originally before the circuit court, one of the key issues I believe that you were asking for, if I'm not mistaken, is that you had filed a case in Delaware and you were seeking to have this action stayed while that proceeding went forward. Is that correct?
That is correct, Your Honor.
Okay. What is the status then at this point? Are you still requesting that, or of the issues you raised to the circuit court, what
Yes.
are you now, asking this court to do in terms of those particular issues?
Well, Judge Hummel denied the motion to dismiss and stay, and the Delaware action has been stayed by the Delaware court. So this action is going forward. Judge Hummel's order of October 22 addresses that, and we have not challenged that. So that issue, as far as we are concerned, is at rest and has been resolved.
So really, correct me if I'm wrong, but you're asking this court in the sense of you believe Georgia law should apply to the contract claims. Is that correct?
Yes, sir, and we agree with Judge Hummel on that.
And so what else are you asking us to do in terms of, if this were to be sent back to the circuit court, on what issues are you wanting us to send it back?
What I'm asking this court to do, Your Honor, is to vacate the portion of Judge Hummel's order finding that West Virginia law applies to the bad faith claims and issue a ruling when you send it back to the trial court that the bad faith claims are governed by the broad choice of law provision agreed to in the policy of insurance at the outset. That is essentially it. So I think the court has two options here. Obviously, you can decide what your options are, but I think you really have two options. You can vacate the portion of the order that Judge Hummel entered determining that West Virginia law applies to the bad faith claims, and you could send it back to the trial court for, I guess, future argument, etc., with respect to that. Or, as we're requesting that you do, you can issue an opinion and an order determining that all claims, including the bad faith claims, are subject to the broad choice of law provision.
You mentioned, counsel, that under the Hoover test that the fifth element of novel issue here, it gets to the crux of the real relief you're seeking. What is from other jurisdictions, and what is the basis upon which you believe this court should provide the remedy that you are seeking, that the Georgia law governs the bad faith claim?
Your Honor, thank you for the question. If you look at our written submission, Georgia law governs the breadth or the scope of the choice of law claim. And if you look at Georgia law, I would refer you to the Axis Specialty Doty Moore Tower case that we cite. It is determined that whenever a choice of law provision encompasses all disputes, that it is a broad provision and therefore does exactly as it says.
That's the crux to my question is,
yes, sir.
Does the broad language in the policy, do we have other jurisdictions who suggested that bad faith under particular state law is controlled by the broad language as you're pointing to in this type of agreement?
Yes, Your Honor, and we do.
Okay.
And so to take a step back, the choice of law provision in this matter says that any dispute concerning or related to this insurance will be determined in accordance with the laws of the state of Georgia. We have cited cases from Texas, New York, Connecticut, various jurisdictions, where whenever you say that any dispute related to this contract will be determined in accordance with this state's law, that is a broad provision, and it encompasses both contract claims and tort claims. And I know there is perhaps some dispute as to whether an Unfair Trade Practices Act claim is a tort or a contract. There's case law out of West Virginia in the Fourth Circuit that some says it's a contract or quasi-contract, some says it's a tort. My position here is that under the case law, it doesn't matter whenever you're dealing with a broad provision. And the various cases that we cited to you from Texas and New York and other jurisdictions, when you're dealing with a broad choice of law provision to which sophisticated parties agreed on the front end, then it encompasses all claims, just like it says it does. And the other point I would make about that is that this choice of law provision is mandatory. It's not permissive. It doesn't say that it may be determined in accordance with Georgia law. It says it will be. And so the parties agreed to that broad provision. It is mandatory. The case law, and this court now has an opportunity to clarify that in our opinion with respect to this broad provision, encompasses all of their claims. And it makes sense in our view for the court to do that rather than just send it back and perhaps it ends back up here again. We think that based on the record that you have in front of you right now, the policy and the information in the record, you have all the facts that you need to make that decision. And
Counsel, I know you've said that you believe this is broad, and I assume that you're perhaps referring to the word related to, because I know there's some case law about using the word related to rather than in accordance with or your other terms. But it also says related to this insurance.
yes.
So does the term related to this insurance does that restrict, if, even though related may broaden it, does related to this insurance, is that restricted in any way?
I don't think so, Judge. I think if you read that and give it its plain meaning, and whenever you use the terminology related to, some use the terminology arising out of, but related to is even broader. So if you say anything related to this contract, the case law is pretty clear that it is a broad provision. I don't think that you will find any authority that says this is a narrow provision or that the reference to the term insurance somehow narrows the scope of it.
But it also says disputes concerning or related. So I guess the question is to this court, is this a dispute, a bad faith claim related to or concerning this insurance?
Absolutely, Judge. There is no doubt about it. If you look at their complaint, the essential nature of the dispute relates to the insurance contract based upon the denial of coverage for this claim. So it is absolutely concerns it, it relates to it, and it is a dispute associated with that. So I think the answer to your question is absolutely. In terms of what this court may do, I think you have the jurisdiction to deal with this as you see fit. And that is, as I said earlier, vacate that portion of the erroneous portion of the ruling and send it back, or decide the issue. And as I was getting prepared to argue today, I was looking at the Liberty Mutual versus Triangle Industries case, which is a case issued by this court in 1990. And the court notes that when the law is not otherwise chosen by the parties is one of the points that the court is making whenever they're doing this analysis. Here, the law has been chosen by the parties, sophisticated parties. And as I noted earlier, I don't think there's any disagreement, even among the parties, that the breach of contract and the declaratory judgment claims are clearly subject to Georgia law. It's been pled that way. But the court went on to say, given the increasingly complex nature of the insurance industry, we believe that the needs of the interstate system of insurance require that law be applied in the most uniform and predictable manner possible. I think that is kind of what we're dealing with here today, is we're asking the court to go ahead and decide this issue for consistency, for uniformity going forward, to give the trial court guidance so that we do not have to go back to the trial court and argue this issue and perhaps end back up in front of this court, Your Honor.
Counsel, you just have a few minutes left, so if you want to save any time for rebuttal, I would ask that you.
I just have one question, Chief, if you don't mind. I'm extending his time a moment, but so what do we do with syllabus point 1 of General Electric versus Kaiser, which I know you know what it says, but I'll just remind, that says a choice of law provision in a contract will not be given effect when the contract bears no substantial relationship with the jurisdiction whose laws the parties have chosen to govern the agreement, or when the application of that law would offend the public policy of this state.
Yes, Your Honor. What do you do with that? First of all, I would say that, as you're aware, the law of West Virginia is that choice of law agreements are presumptively valid unless one of those two exceptions come about. With respect to the substantial relationship, I don't think there is any doubt that there is a substantial relationship, because that is where the insured was headquartered. And so it's not a situation where there's no relationship to the choice of law that is selected by these parties. Here, that's their corporate headquarters. Secondly, with respect to the public policy issue, I would just say that first, nobody has challenged this choice of law provision as somehow violating the public policy of West Virginia. And two, I don't see how they could, because they agreed to it along with the insurers, to be bound by it before the policy was ever issued. So I just don't see any plausible public policy argument. And as the court notes in the case you cite and in others, in order to attack the public policy, it is a very high burden. This court does not undertake that lightly. And that type of proof is just not here, Judge.
Well, it's not here in part because we don't have much record before us, right?
Yes, I would agree, but I would also say that I just don't see how any evidence could develop where you attack the public on a public policy decision, a contractual agreement that you agreed to and understood on the front end. It just seems implausible to me, Judge.
Thank you.
Yes, sir.
Thank you.
Good morning, Mr. Chief Justice and Justices of the Supreme Court. My name is John Sylvester from the K&L Gates Law Firm in Pittsburgh, and I'm here representing Axial Corporation and Westlake Chemical Corporation, who are the plaintiffs in this case and the respondents to this petition. I'd like to spend a minute or two at the outset to give you a little bit of background about our bad faith claim so that you can understand the context in which this bad faith issue is being discussed. On August 27, 2016, a railroad tank car holding liquid chlorine ruptured at a chemical plant that Westlake maintains on the riverbanks in New Martinsville, West Virginia. That rupture caused the chlorine to escape, to vaporize into a cloud from liquid to gas. That gas cloud enveloped most of the plant and some neighboring property as well. And that chemical vapor attacked the surfaces of much of the electrical equipment, the instrumentation, the pipes and pipe coverings in the plant, and caused damage, permanent damage, to much of the plant and equipment at the plant. Now, Westlake immediately notified its property insurers. It had substantial property insurance that it had paid lots of premiums for. And the insurers initially sent their adjusters and their experts and their consultants to come down to the plant to survey the damage, see what was damaged, what was not damaged, what was pre-existing damage, what was new damage, and to value that damage. And for the next 16 months, we cooperated with them, and the insurers never suggested that there was any reason why this accident was not covered. They never sent a reservation of rights letter. They never sent us any sort of letter or orally to say that this might not be covered. They were fully aware of the nature of the damage that occurred. But in December of 2017, about a year and a half or a year and 4 months later, they finally got a report from their experts as to how much it was going to cost to repair all this damage, and it was over $200 million. Well, it was like a light switch went on. The insurers did a 180. They immediately got rid of those experts and consultants and hired new experts and consultants. They hired coverage counsel, and they then went on a path of trying to find ways to avoid paying this claim once they realized how, what the magnitude of the claim was. And so they did bring in new experts. Again, they didn't tell us that they were going to deny coverage. We continued to cooperate with them for the next year or so. They said that they were conducting a good faith investigation. But on April 9th of 2019, while we were in the middle of responding to yet another request for information, they jumped us in Delaware. They filed a preemptive declaratory judgment lawsuit in Delaware, which a state that has nothing to do with any of this, obviously because they knew they were going to deny coverage and they didn't want to litigate here in West Virginia. And they sent their denial of coverage letter with their declaratory judgment complaint, served them both at the same time so that we didn't get advance notice that they were going to deny coverage. Now, they've admitted, since then that they had decided to deny coverage months before. They just never told us. So this 180-degree reversal of their position, the fact that they, in essence, pretended to be investigating, sending all of these people to our plant, asking questions, getting, in essence, free discovery, free pre-litigation discovery, is part of our bad faith claim. And so you can understand that the bad faith claim involves bad faith claims handling with the activity of their adjusters, their experts, and their consultants at the plant, because they were basically living there for months, if not years, after the accident. Now, what happened after they jumped us in Delaware? Well, we filed the next day in Marshall County Circuit Court our own case, and we included a breach of contract and declaratory judgment action, but we also raised a claim under Georgia bad faith statute and under West Virginia's bad faith claims handling statute, the Unfair Claims Practices Act, and common law bad faith as well. And there was a forum battle, as you might suspect. We got the Delaware judge to agree to stay that Delaware case. They nonetheless pressed forward with their motion to dismiss the West Virginia action, even after the Delaware judge had ruled that he was going to stay the Delaware case. And so we went before Judge Hummel on September 5th, a little over a year ago, on their motion to dismiss our West Virginia action in Marshall County. Judge Hummel correctly denied the motion to dismiss because West Virginia had a much more substantial relationship to this dispute than Delaware, which had no relationship to the dispute. However, after the ruling, Judge Hummel surprised everybody in the courtroom by making some sua sponte rulings that nobody had ever asked for, nobody had filed a motion for, nobody had briefed on the issue of choice of law for our bad faith claims. What Judge Hummel said was that he didn't think we could maintain simultaneously a Georgia bad faith statutory action and a West Virginia bad faith statutory action, and therefore he was going to dismiss the Georgia action because he felt West Virginia bad faith law applied to this particular dispute. And it does, of course, given that the property is located here, the accident was here, the claims handling activity was here, and nothing happened in Georgia. So after that ruling, the case was transferred. It had been previously requested to be transferred to the business court. Judge Wilkes had taken jurisdiction over it. Judge Hummel entered his written order from which this petition is now drawn, and that's why we're here today. Now, the thing of it is that while this, we've been waiting to have this argument. It was originally scheduled for May, and then because of the pandemic and shutdowns, it was pushed to September. Judge Wilkes has said that we can go ahead, and in fact, this court has said that we could go ahead with discovery on the breach of contract and on the declaratory judgment counts, and the bad faith claims were stayed by Judge Hummel, presumably pending a decision here. And so we're engaged in discovery right now, and right now the insurers have served discovery on us on the very choice of law provision, which they say is unambiguous and must be construed to have bad faith claims governed by Georgia law. They've served document requests on us about the drafting history of the choice of law provision. They've served interrogatories about that. They've served a subpoena on the broker, Willis. They say, you'll recall, the broker involved in placing the coverage, and they specifically asked for any documents about the drafting of the choice of law provision. And quite frankly, we've served discovery on them. We've sought an underwriter deposition about the drafting and negotiation of the policy, and we've also served a claims handling corporate designee deposition notice about what claims handling activity happened and where it happened. So the parties are actively engaged in factual discovery on fact issues that are relevant to the choice of law issue that they're now asking you to decide in the absence of any record. And that, we say, it's lunacy that we should be here deciding this issue in the absence of any record. We, agree, I guess, to some extent with petitioners that the judge's sua sponte rulings on bad faith should simply just be vacated and sent back to Judge Wilkes. We can finish the discovery on this issue. We can present a record to the judge, We can argue it and brief it fully and address a bunch of issues that aren't addressed in the papers on this petition. And then in the ordinary course, he can make a decision, write an opinion, and then to the extent one or either side wants to challenge it, they can come up before this court with a full record, with a full opinion, and with the benefit of the normal ordinary course briefing. There's nothing urgent about deciding this issue right now, and that's why we believe that all of the rulings regarding bad faith by Judge Hummel that were sua sponte should be vacated, including bifurcating and staying the bad faith discovery. That's an issue that Judge Wilkes now can handle and will handle whenever this case is remanded. Your Honors asked Mr. Parker, what's the basis under the rule of writ of prohibitions that you decide this now? And there is no basis for it. There's nothing urgent about deciding this issue now. And in fact, just recently, last year in the Vandera Resources case, this court said that the court should use prohibition to correct only substantial, clear-cut legal errors, plainly in contravention of a clear statutory, constitutional, or common law mandate, which may be resolved independently of any disputed facts. Well, here, there are a number of disputed facts. In fact, I read their petition last night preparing for this argument. They assert a number of facts that they have no record cite for. They say that we chose Georgia as the choice of law, and that Willis, the broker, was involved in drafting that choice of law provision because they presumably want to get around the contra pro forentum argument that they see coming. Well, again, there are disputed facts right now that would dictate that this is not ripe for this court to decide this legal issue right now. But if the court, wants to take up the merits of whether Georgia or West Virginia law or both should apply to our claims, I'll address that with a few points that I think are salient. Number one, the insurers assume, without ever supporting it anywhere in their papers, that there can only be one statute that they have to comply with, the Georgia bad faith statute or the West Virginia bad faith statute. No support for that contention. They say to this court, you have to choose one or the other. Well, we contend that they have to comply with both, that to the extent they voluntarily agreed to apply the Georgia bad faith standards to their claims handling, that's great. But in addition, they're handling claims here in West Virginia. They're doing business in West Virginia. They're subject to West Virginia statutory and common law bad faith claims handling law. They can't contract themselves out of that. West Virginia and the legislature in West Virginia evinced a very strong public policy that they want insurers who are handling property claims regarding property losses in this state to be governed by dictates of good faith and fair dealing, and they're enumerated, in detail, obviously, in Section 3311(4) of the West Virginia Code. They can't contract themselves out of that. They can contractually agree to yet, another standard in addition to West Virginia's standard, but they can't contract themselves out of that. And so we would contend that both statutes would govern their contract. Secondly, they contend that the choice of law provision unambiguously dictates that bad faith claims must be governed by Georgia law, and of course it doesn't say that. There are ambiguous terms like concerning or related to, and that doesn't necessarily govern tort claims about claims handling activity. It's true if there were no insurance contract, there wouldn't be any claims handling activity, but that's not unambiguous. And they never address the policy interpretive procedures and rules of construction here in West Virginia that ambiguities must be construed in favor of the policyholder and consistent with reasonable expectations.
Counsel, we've obviously have a long history of case law relating to disputes over insurance coverage and choice of law provisions. What do you offer this court to distinguish a bad faith claim not falling within the jurisprudence and the suggestion that it's a dispute relating to insurance?
If you look at That's a great question. If you look at most of the cases cited by the petitioners, the out-of-state cases that say that a breach of contract claim necessarily would envelop a bad faith claim if there's a choice of law for the contract, those are commercial contract cases. Almost all of them are. They're not insurance cases. Insurance is a regulated industry. Unlike, commercial private contracts between two parties, where they can agree, presumably, to do anything. They can agree to arbitrate rather than even come to court at all. But insurance is such of a particular importance that the legislature here in West Virginia has said, if you're doing business here, if you're handling claims here, you've got to follow our rules, okay? And so those private contract cases on commercial contracts do not apply. And that's why, even if one were to say that this contract provision is broad enough to encompass bad faith claims, they can't exempt themselves by contract out of following the claims handling regulations here in West Virginia. And that's what the public policy issue is. I mean, first of all, the Fourth Circuit and this court has said that violations of the Unfair Claims Practices Act, 3311-4, are torts. That's tortious type conduct, not contract claims. It said it in the Wilt case. It was the Fourth Circuit recently in Kenny, which, by the way, rejected the Pen Pal case from the Southern District of West Virginia that they rely on to say it's a contract claim, not a tort claim. So these are tort claims. The choice of law for tort claims is lex loci delicti, which is the location where the deleterious conduct took place, where the tort. Well, here the conduct, the bad faith claims handling conduct, was in West Virginia. It was what they were doing and saying, basically subterfuge with our clients, employees of the plant, who, by the way, have a plant to run, and they were continuing to burden them with all sorts of requests for documents, information, et cetera, knowing full well that they were going to deny the claim. That took place in West Virginia. So my answer would be that an insurance case is different than any commercial contract case.
And that's kind of my challenge, is the language so specifically references related to this insurance, and then it talks about this policy. So it seems under your theory that this is really about a contract rather than insurance, this language. And petitioner made reference, I think, 3 times to the sophisticated signer. So you're asking this court to basically render null and void any application of paragraph 22, because you're saying it's contract rather than insurance, even though it says this is relating to insurance and the policy.
We're not asking to render 22 void. I mean, we agree that the contract claim is governed by Georgia law. That's agreed. With regard to our bad faith claims handling, to the extent that the Georgia law, or that choice of law provision encompasses bad faith claim, okay, that's why we included it in our complaint. However, they absolutely still have to follow West Virginia claims handling law. As between the two, West Virginia, of course, has a much greater interest. And that goes back to the General Electric case, which is even if you determine that bad faith claims, insurance bad faith claims, are contract claims and not tort claims, and you don't follow the lex loci delicti choice of law, you don't automatically just simply accept whatever the parties have written in their contract. If application of that specified out-of-state law violates or offends a public policy of West Virginia, it should be disregarded or it should be overruled. And that's what's happened. I mean, that is applicable here in the sense that West Virginia has an extremely strong public policy as to how to regulate insurers, based on a long history of improper conduct. And that's why the legislature put in certain rules about how they must conduct themselves in handling claims, and they can't contract themselves out of it. They can agree to yet an additional burden of following Georgia bad faith law, but they cannot contract themselves out